Welcome to the fourth webinar in our manufacturing series with Insperity, HR that makes a difference. I'm Jennifer Libby, and I'm a district manager with Insperity, and it is my honor to welcome you to our webinar today. Please be very interactive. We'll have a number of opportunities for polls, and at any time answer things in the chat. At the end, we'll get together and talk about the feedback you gave us. So really encourage your interaction. In addition to being a district manager with Insperity, I have over 25 years in manufacturing HR experience. And so I'm extremely excited to introduce you to our presenter as she and I explore some things in manufacturing that is really unique to the HR space. And everybody on this webinar knows that. Lori Sweeney has been with Insperity for 8 years, but she has over 23 years of experience working in the human resources field. Prior to Insperity, Lori worked both in the pharmaceutical and the technology industries in various roles, including a generalist, a manager, and a director of human resources. Lori is a certified professional through the Society for Human Resource Management and also has a certification in HR practices from Cornell University. Again, I'm thrilled to welcome Lori to this webinar series, and at this time, I'll turn it over to you, Lori.
Thanks so much, Jennifer. It's great to be here today. Okay, so today we're going to cover three crucial areas related to HR compliance. And we're going to really try to talk about how this affects our manufacturing clients particularly. So the three parts that we'll talk about are wage and hour compliance, because ensuring your business complies with all applicable wage law is vital to avoid costly penalties and to maintain a fair workplace. We're going to talk through those key requirements and current best practices. Then we're going to move on and we're going to talk about anti-discrimination and harassment laws. Creating a safe and inclusive environment is not just a legal obligation, but it's also a cornerstone, of a thriving business. And we're going to discuss the best practices to help you foster a respectful workplace. And we're going to round it out with talking about managing employee leaves. These situations can be complex, especially with the interplay of all the various laws that could apply. I'm going to provide an overview of those laws, and I'm going to share steps that you can take that will ensure that your business handles everything appropriately.
Thank you, Lori. As I think about the time in manufacturing and HR that I spend, it really does fall, those main buckets are that wage and hour compliance, that anti-discrimination and harassment law segment, and then managing those employee leaves. So I'm excited to hear more. Yeah. Well, I'll tell you, and Jennifer, you know, Insperity understands the unique challenges that you face in managing your workforce. And our goal is to provide you with some knowledge and the tools to navigate these complexities effectively. Employers, especially our manufacturing employers, face a multitude of compliance challenges every day. And while I can't cover everything in today's session, we are going to focus on the areas that carry a high degree of risk if you don't manage them correctly. So let's start off by talking about wage and hour compliance. Both the FLSA and state wage laws were put into place to ensure fair pay practices, and careful adherence to these laws will help your business avoid costly wage disputes. Another aspect that we are going to talk about today is exempt and non-exempt worker classifications and what the differences are between those two. Okay, so we cannot talk about wage and hour compliance without talking about the Fair Labor Standards Act of 1938. It's commonly referred to as the FLSA, and it sets the foundation for the basic labor standards in the United States. That includes minimum wage rates, overtime rules, and a multitude of other regulations. Now, individual states will generally have their own set of wage and hour regulations, and these laws often come with more generous requirements than the FLSA. Now, a good example of how a state law may be more generous is the minimum wage. The federal minimum wage has been $7.25 since 2009, but 2/3 of our country have set higher minimum wage rates. Many of these states automatically adjust those rates based on inflation or on the consumer price index. And while most of the adjustments will take effect on January 1st, There are states that adjust the wage rate at other times during the year. It's a lot to keep track of, especially if you're operating in multiple states. Now, a key principle to remember when multiple laws apply is that your business must always adhere to the most generous requirements provided by any of the applicable laws. With minimum wage, this means providing the higher state required rate to your employees. Now, Jennifer, before we move on, I think that you wanted to ask our audience a question.
Absolutely. Thank you, Lori. And before we jump into the question, thank you for your points on the complexities of so many of those FLSA laws. Easy for me to say, right? And, it has to do with not only is it state, not only is it federal, but sometimes there are county or city ordinances as well. So that complexity and that mid-year cycle really adds a level to that, where it's a great time to reach out for people for their expertise. But back to our poll. So audience, really looking for your engagement on this. We want to know, how does your business currently track employee hours? Is it A, manual punch clocks? Is it B, digital time tracking software? Is it C, biometric systems like fingerprint scans? Or D4, are you doing other things with that? So we're going to take a few seconds to give you time to respond, and then we'll move on to the next segment.
Okay, awesome. Are we ready? Yeah. Okay, a fundamental requirement of wage and hour law is that employers track and keep records for all of the time that's worked by their employees. And generally, this means that you need to have a reliable process for how your employees report their time. And it's also important that your employees are clear on the expectations and the requirements that you've set for time tracking. Now, just like our poll, time clocks are the most commonly used are very commonly used in manufacturing. And today, that probably or might not mean an actual punch clock. It could be an app on the computer or on a phone. You might even require a fingerprint or even an eye scan in order for your employees to record time. And I'm fairly certain that even if you do have the actual punch clocks, they're electronic now. Nobody's collecting those cards at the end of every day. Now, however your employees report their time, there are some common pitfalls that you want to avoid. And let me start with a common misperception is about rounding employee punches. Now, lots of employers still believe that that's okay to do, but it can be very, very risky. While the FLSA does allow for rounding, the law states that it has to be neutral and it does not result in an employee getting paid less over a period of time. Now, if your business rounds punches and you're not auditing them regularly to determine if the rounding is causing even one employee to be undercompensated, your risk of a wage claim is much higher than you might believe it is. And let me tell you, rounding used to be very, very common. I remember the 7-minute rule, applied it myself in HR over the years, but times have changed just like your old punch clocks have changed. The law itself hasn't been rewritten, but the Department of Labor opinion on how to interpret the law has. And there have been many court cases and class action lawsuits related to time rounding. Now, these situations rarely, if ever, work out in an employer's favor. So to avoid wage claims, audits, potential lawsuits, just don't round. Instead, set clear guidelines and address improper employee punching when it happens. Okay.
Lori, just a quick comment on that, if I may.
Yeah.
One of the things that you said was the rounding rule, which I remember very well from my time in HR and manufacturing. And I want everybody on the call to understand that most people are always trying to do the right thing by their employees. It's just easy to miss something. And once there's one claim made or one lawsuit filed, it opens up everything for examination. And it's very rare that as human beings, we don't make mistakes with that. There was an example of a situation I was in as a director of HR at an international company, and we had a complaint I took an incredible amount of my time as the HR director. We spent a lot of money with our employment law attorney. We were successful in refuting that. So we did not have any kind of fine or finding or anything like that, but it was still extremely painful and time consuming and expensive.
Yeah, time consuming, like you said. Why, it's scary to have to go back and dig through and have that worry on you that, oh my gosh, did something we did for convenience sake, for our employees' convenience sake, work against us or hurt them in some way? Nobody wants that. So yeah, I agree. It's a pitfall. And that's why we started with it, because it is certainly an easy one, and it's one that has been around for a long time. Rounding, right? All right, well, let's talk about another timekeeping best practice. Don't auto deduct for meal and rest breaks. Make sure that your employees are actually punching out for any breaks. This avoids underpaying your employees when they happen to work through a break or a lunch. And the danger to employers who do not have those complete and accurate timekeeping records is that an employee's testimony regarding hours that they worked could be accepted as the accurate time if it ever got to court or there was a wage claim and you're dealing with an administrative agency. It's really not uncommon for employers and employees both to say, hey, this is so inconvenient that I have to punch in and out every rest break, every meal break in a shift. But please believe me and Jennifer when we say that it's a minor inconvenience compared to having to deal with a wage claim or a complaint. An audit is going to be much more inconvenient, and it's going to be time consuming. And like Jennifer said, hers wasn't an expensive lesson, but it could certainly turn out to be an expensive lesson if there was even one thing that just wasn't right in the eyes of whoever your auditor is. Okay, so in addition to requiring the live punches for accurate timekeeping, there are some states like Illinois and Nebraska that mandate meal breaks. That means under the law, you have to provide certain meal breaks for your employees. Maintaining precise punch records is essential in those locations because you need to demonstrate that your business is adhering to those regulations. So when it comes to timekeeping, please opt for accuracy over convenience. Record and pay based on actual punches and don't auto deduct time. Now, this might mean that supervisors are going to need to do a little bit more follow-up to ensure that employees are following the company processes, but it is preferable to having to deal with any sort of challenge or complaint later on. All right, nothing to add there. We're good. We're moving on. All right. So another area of vulnerability for manufacturing employers is the Department of Labor's donning and doffing requirements. If your employees need to put on or take off any kind of gear, protective gear, uniforms, whatever, at the start or the end of their shifts, that time could be compensable. And this is especially true if the gear is necessary for their work activities, so they can't actually go and start work without it. For instance, there was a 2016 case against a large food manufacturer in the Midwest. And in that case, the court ruled that the donning and doffing time that they hadn't been paying for was actually compensable, and it resulted in a $2.9 million verdict. So that's a big example. But to avoid any kind of similar issues, it's really wise for you to evaluate whether any donning and doffing time should be included in your employees' work hours. And the solution is very straightforward. If you have employees punch in before they need to don any required equipment and punch out after they have removed it at the end of their shift, you'll be in safe territory. You'll have eliminated that potential risk.
Lori, I'm really glad you brought up that particular suit and that example. I think there's a very common misconception that employees need to be ready to work when their shift time starts. And in the vast majority of cases, that is accurate. But again, with those protective gear or, additional requirements beyond, say, a hard hat and steel toes, that's very, very common. So I really encourage our listeners, if that's something that you're even minorly concerned about, make sure you reach out to an expert to ask.
Yeah. All right. One last reminder under this topic. Be sure you're calculating your overtime pay correctly. You remember that you need to factor in all compensable time, such as shift differentials and non-discretionary pay, like maybe a production bonus or incentive that occurs in that same work period. Now, once you've added in all of your pay, divide it by 40 to determine that regular rate of pay for the week. And that's the number that's going to be used to calculate overtime pay. And I just gave you a very, very simple example. There are a long list of exclusions to what must be factored into that regular rate of pay. So be sure that you're getting professional guidance on what to include or not include, because this is just a point that we really want to bring up. It's not always just that hourly rate. You're paying somebody $15. Time and a half is, oh boy, now I made myself do math. Time and a half is like $23.50 or something, $22.50. Oh, Jennifer, I shouldn't have put myself in a position where I do math. Sorry, guys. But get your payroll professional. Make sure that they are looking at calculating that regular rate of pay to get the overtime rate correctly. It is something that we do see cases and complaints on. And just to sum it up, wage and hour law, like I just started to talk about, is very complicated. And that's why it's so important for you to have a professional payroll partner on your side to help you navigate all of these wage regulations that impact your business. Okay, we're going to move on.
Lori, I love your humor with that situation, but it really brings up a good point, is that there's just so much specificity to that. And we're all moving and doing a lot of things at one time. And so just having somebody really, just keep an eye on that. Again, a lot of misconceptions around what is overtime, I remember hearing a lot, well, if it's in the same pay period, then it's okay. And you're just clearly telling us that's not the case. So great reminders.
Yeah. All right, let's keep moving. Employee classifications. Now, there is more to the FLSA than just minimum wage and overtime rules. The FLSA classifies employees into two categories, non-exempt and exempt. And everything I just shared about wages and timekeeping requirements apply to your non-exempt or your hourly workers. So let's review these classifications and talk about the FLSA requirements for determining exempt positions. Okay. So most workers, as I said, are non-exempt. That means that they get paid by the hour, they're subject to minimum wage requirements, and they must be paid time and a half after working 40 hours in a work week. Exempt status is significantly different. Exempt employees are not paid by the hour. They're paid the same salary every week, regardless of how many hours that they work. They're not entitled to overtime pay because they're not hourly. They're guaranteed their salary. Their salary can't be docked if they're coming in late or they leave work early, or for most of the other reasons that would affect your hourly worker's weekly paycheck. And we're not going to get into the details on what can and cannot be deducted from an exempt worker's salary today. I just want you to be aware that pay is treated differently for exempt workers. Now, exempt roles under the FLSA typically include executive, administrative, professional. You see the other ones on the slide. These are the exemption roles. And to qualify as exempt, there are two main criteria that must be met. The job duties must align with specific FLSA requirements, and employees must be paid a salary of at least $684 per week. And that equates to $35,568 annually. Now, as you're probably aware, the salary requirement had increased in 2024, but it was overturned near the end of the year. So we are back to that $35,568 annual salary requirement. And of course, additionally, there are states that have, especially states with the higher minimum wage laws, that have higher exempt salary requirements. So it's important for you to check your regulations in the states where your business operates to make sure that you're satisfying any special requirements under state law.
It's such a great example, this area of how things are interwoven. I had a specific example of a time when we did an exempt and a non-exempt wage status review when there were some changes a number of years ago, and we determined that a role that we had classified as exempt was actually non-exempt. So we made that transition to the correct amount, and we had different benefit amounts in terms of exempt and non-exempt. So that ended up in somebody filing our claim, an EEOC claim, even though we were putting it into the right section. Again, fortunately, we were successful in not being penalized for that. But the reality is that there are all these unintended consequences with these exemption status decisions that really, really behoove us to sit back and spend some time here.
Yeah. And that's a perfect lead in, Jennifer. Exempt status is so often misunderstood. And I want to stress that job titles don't determine the exempt status. Neither does having a salary of at least $684 a week mean that you can classify as a role as exempt. It's a combination of the actual job requirements plus that qualifying salary that are going to help you determine if a particular role it qualifies for exempt status. And the Department of Labor has really helpful resources called fact sheets that provide guidance on the rules for each exemption type. And I want to give you a quick example. Office manager, right? A lot of companies, manufacturing all across every industry, there are office managers. And because an office manager performs important administrative tasks and has the word manager in their title, a lot of employers assume that the role automatically qualifies for the administrative exemption. But however, there is another key requirement that needs to be met. And I'm going to quote this: the employee's primary duty must include the exercise of discretion and independent judgment with respect to matters of significance. And I know that's a mouthful, and it comes right from the Department of Labor's fact sheet. And it's that criteria that we most often see missing from the job description of an office manager. It's also subjective, so it can be a little challenging. What is a matter of significance? Is it money? What is it? So it's never really clear cut. You want to get some professional help when you're trying to make a determination about a particular role's exemption status, if you're just not sure, if it's not clear cut. Now, going back to that office manager, if the manager's duties are primarily clerical, such as scheduling appointments, processing paperwork, answering the phone, but they don't have any significant decision-making authority, they're not going to meet the criteria for the administrative exemption, and you should classify them as non-exempt. And just in general, the best way to avoid misclassifying positions in your organization is by regularly reviewing the actual job duties and salary thresholds for each position to make sure that they align with requirements, the FLSA requirements. And tactically, that means you need to maintain updated job descriptions. You need to educate your management team on the differences and distinctions between non-exempt and exempt roles so that they know how to manage each group, right? Because like I said, exempt employees' pay is treated differently. Exempt employees should be treated differently when it comes to managing their time and performance. So periodically do a full audit of all of your roles and the associated wages to ensure that you're staying in compliance with all of these applicable wage laws. And I think, yeah, okay, so we just have this one more and then we'll finish this section. So I just to reiterate, thoroughly understanding and carefully adhering to both FLSA and state wage laws is going to help you avoid any costly wage claims and misclassification disputes, because the risks are fines, back pay, and penalties. And these can go so far beyond what the initial complaint was, because once a Department of Labor or a state wage and hour department comes in, they're going to do a comprehensive audit and of all of your payroll practices, and they're going to look back at least 2 years. So the manufacturing industry is one that is more likely to be proactively audited by the Department of Labor. And that's been true for many years, and particularly audited for issues relating to overtime pay and employee misclassification. So to mitigate the risks, accurately track your employees' work time, make sure that your employees and your supervisors are trained on procedures and expectations, and maintain up-to-date job descriptions to help ensure that you're properly classifying every position in your organization.
Lori, that was a mouthful, so I'm going to give you a minute to take a breath there, because I want to just comment on your point regarding job descriptions. That is probably one of the least favorite things for people to do, right? We're a family, we work hard, we all know what we need to do, we all wear many hats. Those are things that are very true in so many organizations. But the reality is when something comes up, and even even if it doesn't come up, but just providing clarity for people, job descriptions can be very, very helpful. We don't need to overcomplicate them. When I was an intern in college doing job descriptions, I think we had one that they were about 12 pages. It was excessive. We learned that we needed to dial that back. But when we have people join the Insperity organization and clients come on after the handbook review, job descriptions is the next most common thing they ask us to take care of because they are so critical. And a lot of times they just haven't simply had time to get them done. And there's such a key aspect of any kind of defense, if you will, or just clarity of communication.
Very, very true. The job description is foundational for so many things. The classification, what if there's ADA accommodations that need to be met? Where do we want to go? We want to go back to the job description because that says it right there in black and white. This is what this role requires. So yeah, great points, Jennifer. All right. Look at this, talking about job descriptions. And this is the other really, really important foundational document. I want to take a minute here to, I almost feel like it's a commercial, but I want to highlight the key risk mitigation tool that your business absolutely must have. And that is an up-to-date employee handbook. All right. It helps you ensure that your business is complying with the latest federal, state, and local laws. And it's going to help mitigate the risk of legal disputes and potential litigation by clearly outlining your policies and your procedures. It demonstrates to the world that your company is committed to following employment laws and regulations. Now, I've heard arguments, and I bet you have too, Jennifer, over the years, that publishing an employee handbook could actually increase your legal liability. But I'll tell you, HR and legal experts are going to say to you every time, a well-written, up-to-date handbook is essential. An outdated handbook could work against you, which is why Insperity recommends that you do a comprehensive review of your handbook at least every 2 years if you are maintaining it manually. In between, you should still be adding or revising any policies that might have been affected by new or revised laws. A good handbook just provides employees with a clear understanding of what is expected of them. It's going to outline your policies, procedures, and those behavioral expectations. And that helps prevent misunderstandings and inconsistencies in what expectations are set by leadership. This clarity fosters a more positive work environment, and it helps ensure that everybody's on the same page. And again, the handbook serves as a reference for both your employees and management, ensuring your policies are consistent, and it's the consistency that maintains fairness and transparency and ultimately contributes to the overall success of your organization. And I don't think I'm exaggerating there, Jennifer. A good handbook is going to contribute to how well and how easily or how smoothly a business is run.
That's absolutely spot on, Lori. And there are so many great areas that we can dive a little deeper into, but I know we've got a lot of good information to cover yet. So keep that in mind if you hear nothing else from this handbook and job descriptions and communication.
Yes, absolutely. And just remember too, Insperity helps our clients. We don't put that burden on you. We take that burden from you, and we help make sure you always have an updated handbook. Just had to say that. I'm so proud of our handbook product. Okay, so anti-discrimination and harassment policies. This is another area that can be so challenging for employees or for employers. And I think, Jennifer, you agree with me? Is there a question we want to share?
I absolutely agree with you. And I think, one of the things that we're looking for, again, is your input. So if you could, audience, take a moment and give us your thoughts on the following question. Has your business had to deal with an employee complaint or regulatory charge related to discrimination or harassment? And you can see our choices, up there. A, yes, you have, or B, no, you haven't. So please take a minute now and let us know if your business has had to deal with that complaint or regulatory charge. Great. Thank you for your feedback.
Okay, so let's talk about anti-discrimination protections. The Equal Employment Opportunity Commission, the EEOC, is another government agency that's charged with enforcing employment laws, and that includes Title VII of the Civil Rights Act of 1964. Now, in many states, actually every state has their own version of an anti-discrimination law that's similar to Title VII. And most of the states provide a broader scope of protection and cover more businesses. So for instance, Title VII applies to all employers with 15 or more employees. But if you're in Illinois and you have even one employee in your business, they're covered by the Human Rights Act. And in Iowa and Kansas, you only need 4 employees under their anti-discrimination laws. So no matter the size of your business, preventing harassment and discrimination is a really smart business move. In 2023, which is the most recent data available, the EEOC reported that they secured over $665 million in settlements related to workplace discrimination. And like I said, each state has their own agency investigating charges, litigating on behalf of employees, and collecting settlement money. So you want to be careful if that's not enough incentive to ensure your business has an anti-discrimination program in place. I want to talk a little bit about the positive effects that having such a program bring to your business. So companies that prioritize both a healthy and respectful workplace experience a range of positive outcomes, including improved productivity, employee engagement, and profitability. And there have been many studies and surveys by companies like Gallup or McKinsey and the Harvard Business Review that support these findings. Now, that I've convinced you how important it is to be aware of your obligations under Title VII, let me break down the components that together are going to help you reduce the risk of discrimination and harassment issues in your workplace. So first, you want to have a comprehensive anti-discrimination and harassment policy in place. It should be in that up-to-date employee handbook, and you're going to want to distribute it at hire. Make sure your employees sign an acknowledgement confirming that they received the policy. So set the foundation at the beginning. But having a policy isn't enough. You'll also want to educate your employees about harassment and discrimination so that they recognize it and they know what to do when they see or experience it. The EEOC recommends regularly training your employees and supervisors, but it's not a mandate. Now, unless you're in Illinois, there it's a requirement under the law to provide annual training. Now, Insperity's recommendation is to provide training at hire and also have mandatory annual trainings for all employees, no matter what location they work in. And we make this really easy for our clients because we offer both live and self-paced courses that comply with any applicable state law. Now, you're also going to need to establish a reporting process, and it's best to provide multiple ways for employees to report harassment, such as hotlines, online forms, and direct reporting to HR. If a complaint comes in, you want to do a prompt and thorough investigation, and you want that person that's doing that to be objective and to have some training, because that's super important. This is a very challenging situation when these things come up. Be consistent across all the levels of your organization when it comes to enforcing your policy. And let me stress, no one, no matter how integral to the business, should be able to violate an anti-harassment policy. So to sum it up, establish a clear policy, train your employees annually, and promptly address all complaints. These are the steps that are going to help you provide a strong defense should a complaint ever come up.
Lori, I want to continue to be sensitive to our time and the amount of information we need to get through, but I must just really reiterate what you said about multiple ways for people to report their concerns. There is such a misconception that, I know my audience, I know who I can do what around. I've seen it over 25 years in multiple lawsuits. The reality is the audience changes. Sometimes people aren't comfortable going to their manager or even to HR. And so providing that anonymous reporting structure, not anonymous, but that other reporting structure is really, really critical.
Yeah, it truly is. You want them to have a way to talk to somebody that is within your organization, because otherwise where are they going? They're going to a regulatory agency, and now it's outside of your hands. So you don't get to remediate it and fix things before you have, outside eyes in there. So. All right, managing leaves is a part of every business, right? People get sick, they're injured, or they need time off to care for a new baby or a sick family member. These absences can be challenging because they impact your operations. And they can also be challenging because the laws that may apply and affect, because there are laws that may apply and affect how you are able to handle that leave situation. So imagine this. There we go. Imagine this. This is an essential employee in your organization suddenly needs an extended medical leave. Now, what questions immediately come into your mind? Maybe, oh my gosh, how long will they be gone? How is this going to affect my business operations? And you might be thinking, do I need to hire somebody right away to fill the position? I can't go without. But if I do that, should I terminate my employee? Right? Lots of questions. Navigating leave situations is never straightforward. And while there are laws that will impact your decision on how to handle a situation, it's not just about ticking boxes on legal requirements. You want to balance your operational needs of your business with the rights and the well-being of your employees. I think we have a question here. How does your organization handle overlapping leave requests, especially when FMLA and ADA requirements may both apply? We're going to put that in chat, ask for answers in chat. Is that right, Jennifer?
We would love to get the answers in chat. Yes, Lori, exactly. So I think, again, speaking that to complexity, just a couple, a phrase answer. How do you handle that? How do you deal with those multiple overlapping? And again, to your earlier point, what is the more generous policy and how do you apply that? So how are you managing it today? We'll take a few seconds for you to enter that in chat now.
Yeah, and while they're entering it, let me keep talking because I know that I want to stay within our time and I've got so much to say. So I want to start talking about the legal requirements. At the federal level, we have FMLA. That's the Family Medical and Leave Act. It's been around a while. You've probably all heard of it. This law applies to businesses with 50 or more employees who work within a 75-mile radius of each other. And that's pretty clear, right? If you have remote workers or if you have multiple businesses, if you own multiple businesses, figuring out FMLA and figuring out if it applies, to your company or to a particular worker can get really complicated really quickly. And then there's that notice requirement. If your business is covered under FMLA, it's obligated to provide certain notices to employees who are requesting leave, even if they don't meet the criteria for coverage. So navigating just this law is tricky, and I haven't even gotten to our state level laws yet. Okay, in the Midwest, Minnesota and Wisconsin currently have versions of family and medical leave laws. Both cover more workers than FMLA, and because their eligibility criteria is broader. Overall, there are 16 states and the District of Columbia that have laws mandating protected family or medical leave. And don't forget about paid sick laws. There are even more of them. 22 states have paid sick laws and more are coming. Missouri's law is going to take effect on May 1st, and Nebraska's paid sick law starts October 1st of this year. Now, paid sick laws require that employers provide that paid time off for the reasons outlined in the law. So you need to consider those laws, those obligations, when an employee needs time off for a medical situation, on top of maybe any FMLA considerations or state level FMLA considerations. Now, I know we have a lot of different size businesses, and you might be on this call and you might be thinking that it doesn't apply to your business because your company isn't covered under FMLA, or you're in a state that doesn't have a paid sick law or an FMLA type law. So you're thinking, maybe I can handle this situation based on just what's important for my business. But hold on, because I haven't mentioned the Americans with Disabilities Act yet. That's the ADA. The federal law applies to employers with 15 or more employees, and it covers a broad range of disabilities. Now, one common misconception is that the ADA only covers permanent or long-term conditions like blindness or having some chronic disease, but it also protects employees who need time off to recover from an injury or an illness, or because they're having surgery and they're going to need to recover. A leave of absence is considered a reasonable accommodation under the ADA, and that means that an employer would be ill-advised to terminate a worker who needs time off for their own medical condition. I can talk for an hour about the ADA, but I can't do that today, so let me just say this. When you have a situation that's covered under ADA, please get some guidance from an HR professional or even an attorney if you don't have an HR partner to help ensure that you're going to comply with all of the requirements of the law. That's a tough one. So I don't want to scare anybody, but you really do need help there. All right, let's talk about some best practices. Because no matter what size your organization, having clear processes in place for handling leave requests is essential. And I've got 6 key points that I want you to keep in mind. Have written policies that clearly outline your procedures for requesting leave under FMLA and ADA in your employee handbook. And I'm talking about that handbook that you are committed to keeping up to date, you know. Educate and train your managers and your supervisors on FMLA and ADA requirements. This will help ensure that they understand their roles and responsibilities. You, as a third point, establish a clear request process. And this can be as simple as making sure that employees know who they should contact when requesting a leave, or you could even implement an automated system for them to do that. The key is to make sure that your employees know how they can make a request. Another point, maintain confidential records. Keep all the medical information and documentation confidential and separate from their regular employee files. Only those who need to know should have access to this information. That should only be 1 or 2 people in your organization. Remind your supervisors, too, that they have an obligation to protect their employees' privacy and not share any sensitive information about their condition with other employees. And I have 2 more, kind of lump them together. I want you to monitor and track your leaves, and I want you to conduct regular reviews of your process. Right? If you have an employee on a longer leave, that's going to require more oversight. So you want to establish expectations to ensure that all the processes are being followed correctly and identify any areas. And when you do a review, you're looking for areas where you can improve it so things run more smoothly. All right. And by following these steps, business owners like yourselves can create a structured and supportive environment for handling leave requests and ensuring compliance with FMLA and ADA regulations while you still meet the needs of your employees. And that's a wrap. So I hope that you found this information helpful. Complying with all of the laws and regulations that apply to your business is a monumental task, but it's a task that you can't push off to the side. So regularly review your processes and policies, make sure they're up to date, keep abreast of new laws, and take time to train your supervisors so that they know how to enforce the policies and can keep those small problems from turning into big ones. Thank you so much for your time today. And thank you, Jennifer, for having me.
Lori, that was a fantastic overview. We really appreciate all your guidelines. And now we'll open it up to questions. Again, looking forward to your questions in the chat and the audience participation as we gather that information from the polls, and we'll be back shortly with that. We're so excited to talk a little bit about those polls now and some feedback and answer the questions in the chat. So Lori, the first question that I'd really like you to talk a little bit about is how can an HR outsourcing provider help streamline hiring, onboarding, and compliance training?
That's a big question.
That's a very big question.
How can they streamline it? I'm going to sound very HR here. You want to have your foundational documents, your job description handy, because when you're looking to hire, you have to write a good ad. You have to know how to, or what the job entails to craft those interview questions. The job description is that foundational piece to really streamline the determining what the position is and the hiring. And then when you get to onboarding, having an up-to-date handbook and taking the time to create a little bit, even a small onboarding process internally to introduce your new employees to their company, pointing out in the handbook, because we know no employee, very rarely is an employee going to sit down and read the entire handbook on their first day. But so you want to point out, here's the company benefits. These are the holidays you get off. This is what our sick policy or our PTO policy looks like. These are important expectations of you. You have to be here and punch in by the right time. Those sort of things. Reiterate the culture, what is expected and what is absolutely not okay for them to do. So like that anti-harassment policy gets introduced and talked about. Did you ask about another thing? I forgot there. We've got.
Well, I think,
onboarding. Go ahead.
I think I asked about hiring, onboarding, and compliance training.
Compliance training. Well, one of the things, and it's so much, being a part of Insperity, we have automated so many of these things, and that is wonderful. To be able to point your employee to a portal and say, there are these modules to go through. That is a wonderful way to streamline things. It's not always within the grasp of an organization to do that by themselves. And if that's the case, I would say just going out and seeing. So for instance, if you're an employer in Illinois State offers a discrimination and harassment prevention training model on their state website. So just being proactive and seeing what resources are available to your business if you don't have a partner who's going to provide a streamlined platform for you.
Great. Okay, so the next question we have, thank you from Marlena Hoffman for asking this. Is there a recertification credit code for SHRM or HRCI? And the good news is the answer is yes. So we will get that out to the participants.
That's fantastic. I didn't even know. Wonderful. That's always helpful.
So the next question that we have, Lori, is how can manufacturers effectively handle employee discipline while staying compliant with labor laws?
I think one of the most important things that you can do is educate your supervisors on those foundational laws, the ones I talked about today. So make sure your supervisors understand how to manage their hourly employees, right? With time clock requirements or attendance requirements. It's actually with the hourly, it's a little bit easier. Hey, you were late today. You were 5 minutes late. So going back to how different exempt employees are, educate those supervisors on what that looks like. I can't dock an exempt employee. What can I do? I can't even stress enough how important it is and how overlooked it can be by a company. They put somebody who was great at their job in a supervisor position, and they don't realize that the person doesn't have those skills that they need to counsel employees. So if I had to say one thing that you can do to make your business run better, educate your supervisors on all of those requirements, keep them up to date on the laws, make sure they understand what handbook policies it's their job to enforce and how to do it right.
Yeah, there's so much there. And as you said, it's, it can be more simple. If it's hourly, it can be more complex if it's not, but great points, Lori, to handle all those situations. The next question we have is from Carrie Obermeyer. She's looking for confirmation on running ADA and FMLA concurrently in the event someone needs well over 12 weeks off. Can you walk us through that a little bit, Lori? And thank you, Carrie, for the question.
Yeah, thanks, Carrie. It's a common question because there is no black and white. This is what ADA requires for this long of a time, right? With FMLA, we understand there's 12 weeks of unpaid job protected leave. Now, ADA typically goes hand in hand because if you're on a medical leave for your own serious medical condition, ADA and FMLA could both apply. FMLA is going to start applying that job protected 12 weeks is going to start the first day somebody is off for leave for that covered reason. And ADA, now that's just hovering around it, right? So if maybe the employee says, hey, I'm not 100%, I can come back, but I have these restrictions. And that's where the ADA requirements really come to the forefront. The employer obligations under Americans with Disabilities Act is significant. There's a lot of expectations on the employer. You're going to have to work with that employee, called an interactive dialogue, right? The interactive process. You're going to have to be creative and thoughtful and not just say to the employee, oh, you said that you need to sit during your shift. But you know what? We have line workers and we don't allow chairs. We don't allow stools. Well, you know what? As an accommodation, you may have to make that exception, right? The law says you need to work with your employee. Keep that employee working if they can. So I hit the end of my 12 weeks of FMLA and my employee still has issues. Can I just terminate them? I gave them 3 months and they need more. Yeah, you can't, I would not recommend termination. You're going to have to continue to work with them because the ADA doesn't say, oh, there is a set finite period where you have to work with the employee and then you can say to the employee, I'm sorry, it's inconvenient. The only recourse, one of the things, the terms under ADA, and Jennifer, I'm sure you know it, undue hardship. If a company is saying this is too challenging, this person has restrictions that doesn't allow for them to get the job done. Now the company starts to evaluate, is this an undue hardship on our business? And I can talk about that and all the implications that go into that and the challenges that go into really proving undue hardship. But let's just say that's where I said, get an HR professional who's good with these situations or talk to an attorney to help guide you. Because again, the requirements under ADA are significant.
Yeah, that's a great point. And the reality of proving undue hardship from a business perspective is a very high threshold to hit. So thank you, Lori. Marlene Hoffman had a great point in the chat, and she talked about how having some people don't have access to a computer and you use a self-serve portal. So I know one solution that Insperity has is we have an app on our phones. And so most people do have smartphones now. And so that app is very, very helpful. The other solution I would suggest is providing a terminal, some kind of PC portal in there. So now we're going to move forward to our poll results. So shifting to that, we should have some poll results that we can put up on the screen. But while we do that, you know, one of the things that excuse me, so I'm just going to go through those results. So has your business had to deal with employees complaining or regulatory charges related to discrimination or harassment? So 76.9% of you said that you have. So I'm sorry for that. It's a lot, but the reality, it's hitting people hard with that. So make sure you have a good resource for people, a good resource for your company, and a trusted advisor you can talk to. And could we flip back to that other poll result, please, quickly? How does your business currently track employee hours? So we're seeing 25% of you saying manual punch clocks, and then 58.3% of you are saying digital time tracking software, and 16.7% of you, so good for you, you techies, are using some biometric scans with that. So thank you guys for participating with that. We really, really appreciate that. I know we're a little over time here, so just want to move forward and say thank you to the attendees, all of you, for participating. Thank you for your active engagement in the chat, with the questions, with the polls. Thank you to Lori Sweeney for all your expertise. It's been a delight to partner with you on this in our 4th series in our manufacturing webinars. A reminder to all the participants that we do have these recorded and they are available through Insperity to go back and share with others or look at again, and really encourage you to schedule a consultation with Insperity or download the checklist. It's really, really helpful. Again, the complexity and the amount of regulations and communication required federally on a state and local level, so important. And, Insperity certainly supports those compliance efforts. I think, Lori, one of the biggest points I heard you say is that how interwoven everything is, right? And how many things affect here, the ripple effect here, and going forward. So again, thank you, Lori. Thank you, Insperity, and thank you most of all to all of you who have attended. We appreciate you very much.
Thanks, everyone. It was a pleasure.